Good morning, everyone. This is Melanie Pate. Hopefully everybody can hear me. I want to welcome everybody to this webinar regarding this very timely topic of getting back to work and what we all need to be thinking about as businesses and employers for reopening and doing it in a safe and healthy way that allows our employees to be comfortable coming back into the workplace and also allows employers to comply with all of the variety of laws that will be applicable during this period of time of bringing everyone back to work. As you all know, most states are at this point in their gradual reopening phases. Some states are further along in that process than others. So I want to start this presentation just by, I know we have a lot of employers on today from different states, and so I'm going to be talking generally about best practices and mostly federal laws that need to be considered when you're looking at your return to work plans. But please make sure that you're aware of any state or local guidance or requirements or guidelines that might apply to your particular area or workplace going forward. So most workplaces are doing this reopening in a phased or incremental fashion, and most employers are coming up with plans right now that basically have phases of reopening, such as very limited capacity in the office on the phase, and then capacity on the second phase, and then incrementally going forward. And so what employers want to think about is learning what works and what doesn't work in the first phase and making tweaks and changes to their plan as they go through and improve to the next phases. Obviously, for the time being, the most advantageous workplace configuration is to continue with having people work remotely if they possibly can, which obviously keeps everybody at a distance, but that is not ideal, obviously, for a lot of workplaces, and many businesses and employers will have a need to bring people back into the workplace. So we're going to talk today about the pillars for a safe and effective return to work protocol. And those pillars are listed here on this slide. And so we're going to go through these in some more detail during this webinar. I'm going to go through my content for about 5 minutes, and then we'll have questions for the last 20 minutes of the presentation. So please, if you have questions, put them in the Q&A chat box that you should see on your screens, and we will ask as many of those answers questions as we can during the second part of the webinar. The first safe and effective return to work policy is employee testing and screening. You're also need employee safety precautions in place. You bring people back into the workplace. You're going to want to make sure you're aware of all of the different employee leave available and used by employees as they either return to work or do return to work. You're going to want to look at staggered work schedules, and we'll talk about some examples of how you can do that. You're also going to want to look at your policies and your handbooks and see if you need to temporarily or even permanently revise policies and handbooks to take into consideration your return to work policies and your protocols. And then we're going to talk a little bit about regular and effective communication and how absolutely vital that is now to making sure you are in touch with your employees, they feel safe and comfortable and coming into the workplace, and also as a way to avoid possible liability going forward into this. All right, so let's get into some details on employee testing and screening procedures. The EEOC has issued guidance which states that COVID-19 related inquiries and medical exams can be done if they are job related and consistent with the business necessity. The EEOC has directly stated that they do consider COVID-19 screening and testing to be job consistent with business necessity during this coronavirus crisis period. So there are some options that you can look at for testing and screening of your workplace. You have to remember that if you are going to be doing daily testing and actually doing COVID-19 testing, which isn't really very practical or available employers these days, but if you can do it, you are allowed to do it. It does have to be accurate and reliable according to the EEOC. You can also do other things such as temperature checks at the beginning of the day. You can daily or every other day questionnaires where your employees will be required to fill out a questionnaire. I've been working with several clients on their questionnaires, the types of questions that you would want to ask for your employees while you're trying to screen them to make sure you're keeping people who have COVID-19 or have been exposed to COVID-19 out of your workplace. You need to remember that the results of that screening always must be kept confidential in the same way that you keep information related to FMLA leave requests or ADA reasonable accommodation requests. You need to keep that information confidential and separate and apart from employees' other personnel files. You also really should, if you're going to do daily testing of any type or daily screening, consult with both counsel and a healthcare provider if you can, if that's feasible, to ensure that you have a protocol in place that is lawful and also medically appropriate. If you're going to do daily or weekly, you should also be aware, as most people are these days, that may not screen out all potentially infected employees, because as we know, a large percentage of people who are infected with COVID-19 are asymptomatic. And so although the screening is a cost-effective mitigation strategy and is definitely recommended, you need to also recognize that it may not screen out all employees who may be infected with the virus. And again, any symptom certifications or screenings that you do, those results must be kept confidential at all times. So if you have questions, you can find symptom certification or symptom screening questionnaires on many different sites. On the SHRM website is a good one, or you can look on the CDC website. There's a listing, easy to find listing of all of the different symptoms of COVID-19 that you should work into your symptom questionnaires. Okay, so some issues with employee testing and screening procedures. Are employee testing and screening procedures mandatory as of now? No, they are not, but you understand that the OSHA's general standard for employers is that the employer must recognize any potential serious danger or hazard to their employees that could cause serious health or even death, and the employer has an obligation under the Occupational Safety and Health Act to remove the hazard from the workplace. So in these times, that means that the employer does have a legal obligation to at least attempt to identify potential hazards such as COVID-19 and take steps to remove that hazard from the workplace. So it is highly recommended that you do some type of screening procedure. So what are the pros and cons of testing and screening? Well, the pros are that you can use your testing and screening process as evidence that you have engaged in a good faith effort to protect your employees. The cons are that if the testing is inaccurate, it could create a sense of either a false sense of either security in your workplace or of concern. Some studies have shown that the quick result tests for COVID-19 could have a false negative rate up to 15%. So if you're going to be doing actual COVID-19 testing with the rapid result tests, you need to make sure that you're using a test that is accurate and reliable, which is the EEOC standard. A lot of employers want to know what should they do if they have an employee who tests positive for COVID-19. And our general advice is that you should inform the other workers in the area who work in the same office or workspace that an employee has tested positive. You should never disclose the actual identity of the employee to your other employees, but you can provide some general details about the employee's job duties, where they work or where they have worked, and the general workspace, so that your other employees can properly analyze and evaluate whether they may have been affected. And if you have coworkers who worked very closely with the person who has tested positive, you should talk to those employees specifically and even talk to them possibly about quarantining for 14 days, self-quarantining if they had close contact with the employee who tested positive. Okay, so moving on to employee safety precautions. There's so many different things that employers can do and should do when it comes to employee safety precautions when you have people come back into the office. The first one and the most obvious one is to require employees who are sick, whether or not they've been tested for COVID-19, to stay at home and to not come to the workplace. That's very important first parameter for your safety precautions. You want to allow all of your employees to wear masks over their noses and their mouths, or if not actual masks, at least cloth face coverings, which is recommended by the CDC, and also allow them to wear gloves if they prefer to do so. If you're going to require your employees to wear masks during your opening phases of coming back to work, you're going to want to provide that PPE to your employees if at all possible. Or if you can't provide it to your employees, at least to reimburse them for the expense of them having to either make or buy their own mask or gloves. You can require that PPE be worn while at work and while in the office. If you have people who need to use alternative forms of PPE as a reasonable accommodation for a disability, you need to take into consideration those requests on a case-by-case basis. Those requests could be related to a disability or potentially related to a religious accommodation. So just make sure you have that on your radar screen. You also need to be advising your employees to avoid physical contact with others whenever possible. As we all know, social distancing is the new norm and should be at work. And so there are a number of different ways that you can do that. You should encourage the use of telephonic and/or video meetings whenever possible, even if people are in the office. Limit the number of attendees for any in-person meetings, and also while doing that, making sure that you're using meeting spaces that allow people to be at least 6 feet away from each other, and also encourage them to stay 6 feet away from anyone else with whom they interact, such as clients or customers or vendors, whatnot. You're going to want to look at reconfiguring workspaces, which could include changing traffic flows in the hallways, in the break rooms, in the restrooms. You're going to want to use prominent signage to encourage hand washing and to encourage social distancing so that it's always top of mind for everyone. You may need to reconfigure your actual workspaces, how far desks are apart from each other, whether or not you feel that you need to use plexiglass partitions potentially to keep people distanced from each other. You're also going to want, especially during your first phases of employees coming back into the office, you're going to want to distribute some sort of accessible and easy to remember instructions for each phase, reminders that people can keep in their work area and at their desk of the things that they need to be doing and staying mindful of while they're in the workplace. If possible, you're going to want to speak with your building manager or your property manager about any adjustments they've made to air circulation in the building, potentially keeping windows and doors open more often so that you can circulate more air and more fresh air within the office. Additional safety precautions include requiring employees to use their own dishes, their own silverware, bring their own water, bring their own coffee, close or restrict the use of your common areas, your conference rooms, your meeting rooms, restrict outside visitors to the workplace, and for the time being, encourage only online meetings. Make sure you've got alcohol-based hand sanitizer and cleaning supplies widely available in your workplace, especially if you have areas or equipment where employees are sharing the equipment, and make sure you're encouraging them to and really requiring them to use alcohol-based wipes to clean the equipment before and after they use them, and also cleaning workspaces and work areas on a regular basis, especially if you've got, for example, printers that are used by a number of people in the office. Make sure you've got cleaning supplies near those shared printers and other types of equipment, and make sure they're being cleaned on a regular basis. You also want to encourage your employees to report workplace health and safety concerns immediately, so that if they see things that maybe you didn't see, or they have suggestions of ways to keep a safe and healthy work environment, that they feel comfortable bringing those suggestions and concerns forward to their managers. Okay, so let's talk for a few minutes about employee leave and accommodation options during this return to work period. There are a number of federal laws that you need to be aware of and keeping in mind when you're bringing people back to work and talking to them about their particular situations. Your employees might be eligible for leave and or accommodations under any of these laws listed here on this slide. The first one is the new Families First Coronavirus Response Act, which hopefully everybody is aware of. It went into effect on April 1st and will stay in effect through December 31st of this year. The FFCRA includes provisions for emergency paid sick leave, which generally speaking allows paid sick leave for employees who need to be off for COVID-19 related reasons. It provides for either 100% pay or 2/3 pay, depending on the reason for the leave, and it is fully reimbursable to the employer through tax credits. So if you're not up to speed on that law, please feel free to reach out to your counsel or find information on the law. Make sure that you have posted the information, the required poster regarding this law in your common areas where you post all of your other employee protection related notices. That should have been done on April 1st, but if you haven't done it, make sure you do it as soon as possible. And also the other part of the FFCRA is the expanded FMLA provision, which allows for up to 12 weeks of paid leave for employees who need to take time off to take care of school-age children who are out of school or out of daycare because of COVID-19 related reasons. So those are two major new developments in paid sick leave and FMLA leave that you need to be aware of. Now, the expanded FMLA leave is only another category of FMLA itself. The old FMLA, as we call it, or the prior FMLA, family and medical leave, is still in place and is still available for employees to take. That is unpaid leave and may be taken in conjunction with the employer provided sick leave or PTO benefits that the employee also has access to. Make sure you're also thinking about the Americans with Disabilities Act as people come back into work, especially those people who have underlying disabilities that make them more vulnerable to coronavirus complications. And I'll go through those in a second, what those conditions are. You also need to be aware if you have state paid sick leave laws, which many jurisdictions do have these days. Make sure that you're allowing people to take advantage of state paid sick leave laws if that time is available to them and they need it. You also need to be aware that workers' compensation laws could come into play if an employee alleges that they came back to work and were infected because they are back at work, or that the reason for their infection is that they're back in the workplace. Workers' compensation could apply. Notably in California, Governor Newsom just recently issued an executive order which states that if an employee goes back to work and becomes infected within 14 days of being back at work, there will be a presumption that the employee caught the virus at work and therefore will be covered by workers' compensation. And it will be the employer's burden to prove that the employee did not contract the virus at work, which will obviously be a difficult burden for employees to carry. I'm not aware of that type of executive order being in place in any other states, but it remains to be seen if other states adopt that same approach. Employers also have paid sick leave and PTO benefits in varying degrees that might also be available for employees to use right now. So any requests that are made by your employees to use any of these types of leave have to be considered and evaluated on a case-by-case basis. Make sure you have knowledgeable human resources professionals or counsel to help you work through and evaluate any requests that you receive for leave under these laws. All right, so as far as employee leave and accommodations options go, these are the high-risk characteristics that are currently listed for people who have either are age 65 or over, or have underlying medical conditions. And so these are the high-risk groups that should, under most state and federal guidance right now, should actually be remaining at home and continuing to shelter in place and not be out in public gatherings, but may be able to return to work on a limited basis or with accommodations. These are people who may have chronic lung disease or severe asthma, serious heart condition, or maybe immunocompromised for any number of reasons, people with diabetes, severe obesity, chronic kidney disease, and liver disease. These are all the different types of characteristics that are currently characterized as high risk. So the EEOC issued some guidance on May 7th, just last week, regarding the issue of accommodations for people who have underlying health conditions or are considered to be high risk. And so what the guidance says in a nutshell, and it's a little bit unclear how this will be able to be applied in a practical way, but this is what it says. It says that if an employee does not request an accommodation, the employer is not required to provide one, even if the employee might qualify for one. So the employee does have to still request the accommodation. Now, and if an employer knows that the employee has some sort of underlying condition or high-risk characteristic, the employer cannot exclude that person from the workplace or take other adverse action just because the person has that particular characteristic. However, there's an exception to that. The ADA does allow that type of action or exclusion from the workplace if the employee's disability poses a direct threat to his or her health that cannot be eliminated with a reasonable accommodation. And so in order to determine a direct threat, the disability must pose a significant risk of substantial harm to the employee's own health. Now, even if the employee's disability does pose a direct threat, the employer is supposed to try all types of reasonable accommodations before they actually exclude the employee from the workplace or force them to not be at work. A potential accommodation obviously includes continuing to work from home, but also includes potentially barriers between employees who have high-risk characteristics if they cannot work from home, or elimination or substitution of marginal job functions that that person might have, or potentially modifying the job schedule or the workplace. So this is a somewhat difficult analysis for employers to go through when they're trying to figure out if the employee's disability does pose a direct threat to his or her health that can't be eliminated by a reasonable accommodation. So again, it's a good idea to make sure you're getting good advice on these issues from either a knowledgeable HR professional or a knowledgeable employment counsel who can help you work through this analysis. All right, so some other things that employers are going to want to think about during this period of time are staggered work schedules. You may have heard that employers are thinking of creative and different ways to stagger the ways that they have people coming into the workplace. Always, you might want to consider giving employees the option of coming into work voluntarily or returning to work voluntarily, while also taking into consideration any lower percentage capacity rules that you have in place during your first phases. You might also want to stagger the days or the shifts during which employees can return to, or will return to the office. So an example of that is having possibly 50% of your workforce come in on Monday, Wednesday, and Friday as we move further along in the return to work phases, and then 50% working Tuesday and Thursday in the office so that you are keeping with the goal of having fewer people in the office rather than more people in the office, which will make it more difficult. The more people you have in the office, the more difficult it becomes to avoid congregating, and also to keep social distancing rules in place. You also might want to stagger the hours or the periods during which your employees are taking their lunch or their breaks, so that you have, again, fewer people in common areas where people could be near each other. I want to talk for a minute about revising your policies and your handbooks. It's important for you to consider whether your handbooks need to be revised. And if you do revise your handbooks, make sure you circulate the revised policies or handbooks to your employees so they can review them and acknowledge them. It's really important. Communication is really, really important right now. And it's also important for your employees to acknowledge that they understand the new rules, they understand the new policies, and that their acknowledgement of those policies will be kept in their personnel files. And the reason you want to do that is because your employees need to be informed that any violation of your new policies and procedures could potentially lead to disciplinary action if that becomes necessary or appropriate. And so along those same lines, you want to be considering how you will enforce the new policies and procedures if you have employees who disagree or challenge them. And as we all know, if you've been following the news, there are varying viewpoints on whether masks are necessary or should be used either in public or at work. You may have employees who don't agree with your policies, your safety and health policies and your precautions, and either don't want to follow them or want to challenge the need for them. And so you're going to want to decide who your quote-unquote enforcer will be in your workplace, who is going to be the one to talk to employees if they are not following the policies, who's going to be responsible for doing that, whether it is your human resources staff or whether it is line managers and supervisors, whatever makes most sense for your workplace. But you're going to want to think that through before you bring people back to work so that you have a plan for enforcing the new policies so that you can keep everybody in the workforce as safe as possible. Like I said, employers should regularly communicate with their employees about the new policies and directives that will be in place going forward. And in employees, studies have shown that employees who feel that their employer cares about them and is listening to them and is concerned for their health and their safety and their well-being, they are less likely to complain to outside entities such as the Department of Labor, OSHA, the EEOC, et cetera. Congress is still debating whether or not employers should be held liable for coronavirus infection that occurs in the workplace, or whether they should be shielded from that type of liability. There was a Senate hearing about employer and business liability that occurred just yesterday. And there are varying viewpoints on whether employers should be shielded from liability for COVID-19 infections that occur in the workplace or whether they shouldn't be. But for now, our best advice to employers is to put in place effective safety and health precautions and policies so that you can demonstrate that you were attempting right from the get-go in a good faith way to protect your employees and protect people who come in contact with your business or your organization, and be able to show that you were taking these policies seriously, you were taking guidelines from the state and from the CDC seriously, and you were taking steps to keep your environment as safe and healthy as possible. And that will go a long way if and when you might ever face any sort of lawsuit or potential claim of damages going forward. Okay, so we wanted to make this an opportunity for people to ask questions and get specific questions answered. So my colleague, Hannah Dolsky, is going to be looking at your questions and asking those questions of me, and hopefully for the next 30 minutes or so, we can take as many questions and answer as many questions as we can.
Hi, Hi, so this is Hannah. And so the first question, Melanie, that we have is, can an employer send a sick employee home, and if so, for how long?
Yes, you send a sick employee home, and you should send a sick employee home. And especially if they are exhibiting symptoms of COVID-19, you should send them home and encourage them to consult with their medical provider, see if they can have access to a coronavirus test. Testing is becoming more and more available, especially if you have a doctor recommending that you get the test. And so if a person does test positive for COVID-19, they should stay out of the workplace for at least 7 days. And these are CDC guidelines, for at least 7 days from the date that they first show symptoms, or longer, or if at least 72 hours from when they had the last symptom without having any medication. So, for example, if their last day of having a fever was on a Wednesday, then they need to stay at least 72 hours from when they had they last had the fever and it wasn't controlled by taking Tylenol or some other kind of medication.
Perfect. Okay. The next question is, what if a family member tested positive for coronavirus, but the employee, him or herself, is not sick? Can we tell them that they are not allowed to come in for 14 days? And if so, 14 days as of when?
Yes. So as part of your questionnaire for screening people to come back to work, one of the questions that you should include is whether or not the person is living with or taking care of someone who has symptoms of COVID-19 or has tested positive for COVID-19. And if the answer to that question is yes, then yes, you should have that person self-quarantine for at least 14 days, and then, or as long as the person that they're taking care of is still symptomatic and potentially could be infectious. So you're going to want to have a discussion with that employee about their particular situation and whether the person, what the situation is with the person that they're living with, who either has symptoms or has COVID-19. But they should stay out of work for 14 days at a minimum, but it could be longer potentially.
All right, and we will go to the follow-up question related to this, which is that in regards to the scenario of an employer sending an employee home for being sick, does that time away count against the employee's sick time, or is it employer paid?
Well, if the employer is sent home because they're sick, because they have COVID-19 symptoms, or they're seeking a diagnosis for their COVID-19 symptoms, then they would be eligible to take the emergency paid sick leave under the new FFCRA law. And they should be allowed to take that paid sick leave for up to 2 weeks. And if they do take that emergency paid sick leave because they themselves are sick, then they need to be paid at 100% for that time off. And then they also, once that time off expires, that paid time off expires, they should also be allowed to take either employer provided paid sick leave or paid time off, and or a state paid sick leave that might be available to them.
All right, and then next question is, should I send employees who are potentially exposed to the coronavirus to the workers' compensation doctor for exposure evaluation before requiring that the employee quarantine?
Well, if you have concerns that the employee may have contracted the virus at work, then you should have them go through your regular workers' compensation procedures, and and have them file a claim and have them see the workers' compensation doctor. But the most important thing is to get them out of your workplace. So if they can go home and have a telehealth consultation with your workers' compensation doctor, that would be the ideal way to handle that.
Perfect. So the next question is seeking confirmation that testing should be at the expense of the employer.
Yes, testing should be at the expense of the employer if you're going to require it for employees to come back to work. But you can also, as part of your questionnaire, your screening questionnaire, you can ask people if they have been tested on their own for COVID-19, and if they have been tested, what was the result of that test, and how long ago was it? Now, again, I want to emphasize that the person who's doing the screening and administering the screening want to make sure that you're keeping all of this information confidential.
All right, and then related, if you as an employer require others who could have been exposed to be tested, should the employer pay for those tests as well?
I'm sorry, Hannah, can you repeat that again?
Yep. So following up on the last question, if an employer requires others who may have been exposed to the virus to be tested, should the employer pay for those tests as well?
Yes, the employer should pay for those tests as well.
All right. The next question is, if an employer is unable to reconfigure desks to be 6 feet apart, do physical barriers such as cubicles satisfy the social distancing requirement?
They could potentially. So if you have desks that can't be reconfigured so that they're at least 6 feet apart, you might want to consider things such as staggered shifts. If you can do that, having people work on every other day in the office so that you can keep people at a distance of 6 feet. You can also consider using plexiglass dividers or partitions so that you at least have a barrier between the desks if you can't actually move them 6 feet apart. There are different things that you can do if you actually can't reconfigure the workspace in a way that keeps people 6 feet apart. But again, the overall goal here is to keep at least that much distance, or at least a barrier between people when they're going to be, in the same workspace for 7-8 hours a day. And so staggered work shifts are something that a lot of employers are using to reduce the number of people in the office.
All right. The next question is, if we allow teleworking, but an employee says they are too overwhelmed to care for their kids at home in addition to doing their work, does the employee qualify for any FFCRA leave?
They could potentially, yes, they could. They can either take that, if they say that they are not able to work or telework at home, but the work is available, but they just can't do it because they're overwhelmed with childcare issues because of coronavirus, then they can take the extended FFCRA leave. And remember, that leave will only be paid at 2/3 pay, and it is reimbursable through tax credits. Now, another option, if someone says that they can work intermittently, but they can't work full time, is that the employer and the employee can agree on some sort of intermittent leave schedule where they can use FFCRA leave. But the employer has to approve of that type of intermittent work. That's up to the employer. And if the employer thinks that won't work for that employee and the type of job that they do, the employer can say no. However, the downside to not being flexible and trying to work with your employee is that if you don't allow intermittent leave, they could just say, okay, then I'm going to take full-time FFCRA leave, childcare leave, for up to 12 weeks. So the guidance from the Department of Labor says that employers, or it encourages employers to try and be flexible with employees who need to take some type of leave or have a limited schedule because they've got childcare issues. And so that's where the guidance is at this point.
Perfect. The next question is, if public employers are still excluded from reimbursement under the FFCRA?
Yes, as far as I know, well, public employers do have to allow for employees to take this type of leave, but it's my understanding that they are excluded from actual reimbursement. And remember too, the FFCRA only applies to employers who have less than 500 employees. It doesn't apply to larger employers.
All right, the next question. Can we give employees EFMLA if schools are open but they don't want to put their kids back into school or daycare?
Now, according to the DOL guidance, the employee has to provide you with documentation that shows that their child's school is closed due to coronavirus or their daycare. So in order to qualify for the leave, they have to be able to show you that their child cannot go to a school because it's closed. So it's not just, it's not allowed, or it can't be applied to situations where the parent just doesn't want their child to go back to school.
Perfect. The next question is seeking confirmation that it is in fact a best practice to require employees to wear masks.
Yes, at this point in time, it is a best practice to do that. And the reason for that is because the CDC has specifically stated that it is recommended for employees, not just employees, but for the public to use a cloth face covering of whatever kind that might be that covers their nose and their mouth and chin while they are outside of their homes, which would include being back in an office environment.
Okay, the next question is that most employees are working remotely. In that case, can we require employees to take a test before coming back to work?
Yes, the EEOC has specifically stated that you can require an employee to take a COVID-19 test or be screened for COVID-19 symptoms before they can come back into the workplace. Okay.
Next question. Are there confidentiality HIPAA concerns with temperature testing when employees arrive to work?
No, the EEOC has specifically stated that employers can take the temperature of their employees on a daily basis before they are allowed to come back into work. Now, you also want to remember what I said earlier, which is that just because your employee doesn't have a fever doesn't mean that they potentially are not infected with the virus, because a good percentage of people are asymptomatic. But you can take their temperature. You do have to keep the results of that temperature check confidential.
The next question is, what if an employee contracts COVID-19 during their transport on their way to or from work? Is that employee still covered under workers' compensation?
They potentially could be. The really difficult part of answering that question is that there's no perfect way to prove when somebody may have contracted the virus, right? So you can assume that somebody may have contracted it while they were on their commute or on the train or the bus or what have you on their way to and from work, but there's really no way to prove that that's what happened. They could have been infected in any other place they may have been. So if there's a strong suspicion that they may have contracted it on the way to or from work, you're going to want to submit that claim to your workers' compensation carrier to see if they will cover it. And again, some governors are extending the coverage of workers' compensation requirements right now, but others have not done that. So it's a little bit up in the air as to how much workers' compensation is actually going to cover when it comes to being infected as people go back into the workplace.
The next question is, what if an employee is a smoker and is currently going through breast cancer surgery, but the doctor has released the employee to go back to work? The employee is insisting on coming back to work, but we are very concerned about her risk factors. What should the employer do?
So that is a difficult situation, and if you'll think back to the slide, in fact, I'll put it back up on the screen while we talk about this. So the EEOC guidance on people with high-risk characteristics, and technically under the CDC's guidelines, smoking is not a high-risk characteristic, although lung conditions are. So, arguably, I suppose smoking could lead to a chronic lung condition. But if the person is also immunocompromised because they have undergone recent cancer treatment, then that could be potentially a disability under the ADA. And so you can't, under the current guidance from the EEOC, you can't exclude the person from the workplace solely because they have the characteristic of having recently undergone breast cancer treatment. However, that cancer itself is definitely a potentially qualified disability under the ADA. So what you need to do is, if you want to exclude that person, you have to determine whether the employee's disability poses a direct threat to her health that cannot be eliminated with reasonable accommodations. And so if you believe that this particular employee, if she remains in the workplace, that her underlying condition could pose a direct threat to her health that cannot be eliminated with reasonable accommodations, in that case, you can then exclude that person from the workplace. But with that said, I would encourage you, if you have a difficult situation like that, to really think it through. Make sure you're looking at the EEOC guidance, and all of this guidance is on the EEOC.gov website. It's very easy to find. Consult with a lawyer if you are not certain about how to handle this employee, or at least consult with someone who is knowledgeable about this guidance and understands how to apply it to a particular situation. Because these types of situations are not always easy to figure out, and there's a lot of gray area when it comes to these different definitions. So please make sure you're going through that determination to see whether or not you can reasonably accommodate the person and reduce the direct threat to that person's health. And if you can't reasonably accommodate them, that is the only time that you can then actually exclude them from the workplace.
Great. The next question is, if an employee tests positive, what is the recommendation for disinfecting and sanitizing the office after the positive test? The employer specifically recalls hearing a complete office closure is needed to satisfy the disinfecting and sanitizing requirement. Is that the case?
I have not heard that a complete office closure would be required, but it really depends on your workplace. If you have a small workspace where people are working closely together on a regular basis and around each other, and there's no way to really get the whole area clean without just closing the office space and having the whole area cleaned professionally, then that's what you should do. However, if you have a really large workplace where this person, say, only worked in a particular cubicle or limited area of the office and around limited people, then you can do a more limited cleaning by cleaning that person's whole workspace with disinfectant that is approved, I guess, under OSHA standards to disinfectants. We all know what those are, though: Clorox, bleach, Lysol, the disinfectants we've all been using for several months now. You want to clean off that person's whole area, their whole workspace. You want to definitely disinfect any areas that they use with other people or equipment that they use in common with other workers. So you're going to have to look at that on a case-by-case basis. It really depends on the space that employee worked in and the general surroundings and the type of office area you have, the type of building you work in, those types of things.
Quick one, Melanie. Can you go back one slide? There have been a couple questions just about the specific high-risk characteristics that I think will be answered if we just leave that slide up. And then
I did that.
Thank you. The next question for you is, what kind of guidance should employers be asking their health benefits administrators in regards to COVID-related benefits and workers' compensation claims?
Well, you should definitely be talking to your employee benefits employees and your providers and making sure that everybody's on the same page about which types of benefits will apply and will be able to be used by your employees. There have been some questions about whether, like, if you have employees who are on furlough right now, so they're not actually working, but they're still on your payroll. Does your insurance provider, your health insurance provider, have a requirement that your employees must be working a certain number of hours per week or per month in order to be covered by their health insurance benefits, even if they're on unpaid status right now, but they're still employed? You also want to be, your question wasn't very specific, but you want to be looking at whether your employees can use their paid time off benefits or their sick leave benefits if they need to be off work for COVID-19 related reasons. If you have a more specific employee question, please let me know so I can make sure I'm actually answering the question.
Next up, is there anything else specifically we should be considering when hiring new employees?
Yes, so you can screen your new employees for COVID-19 symptoms. You can also ask them to take a COVID-19 test if you're also doing that with your current employees. You can also put off start dates if you feel like you need to do that at this point in time so that you're not bringing new employees and new people into your workplace right now during this particularly sensitive period of time. There's a number of things that you can do, but the overall goal, obviously, for every employer right now is to do everything you can to create a safe and healthy environment for your current employees. So you definitely can apply the same standards and screening procedures and testing procedures for new employees that you're applying to your current employees.
Okay, next question. If the employee has been in contact with someone outside the workplace that is positive for COVID-19, but the employee's test comes back negative, does the employee still need to quarantine for 14 days?
If the person has been in contact with somebody that they know has COVID-19 and that there is a significant risk that the employee could potentially at some point test positive, then they should definitely self-quarantine for at least 14 days and hopefully be able to have another test before they come into the office that tests negative. You want to err on the side of caution with these types of situations. If you have somebody who knows that they've been exposed or in contact with somebody who has tested positive within the last 14 days, then you want to make sure that person is taking every precaution to not bring that infection into your workplace.
The next question is, can you describe what should be on a return to work screening questionnaire?
Sure. So the first question should be to list the symptoms of the symptoms of coronavirus that are listed on the CDC website, which the CDC recently added several new symptoms to the symptom questionnaire, to the symptom list that they have on their website. So in addition to fever, coughing, and shortness of breath or difficulty breathing, they also added a loss of taste or smell to that list. I'm not looking at it right now, but they also added nausea, vomiting, diarrhea, and a couple of other symptoms that are not coming to my mind right now. But anyway, look on the CDC website. That would be your first question on your questionnaire. You also want to ask if the person has been tested for COVID-19 recently, and if so, what was the result of that test? You want to ask if the person is living with somebody who currently has symptoms of COVID-19 and is seeking a diagnosis, or has tested positive for COVID-19. You want to ask that question. You're going to want to ask whether the person has been living with, or if they themselves have been told to self-quarantine because of potential exposure to the virus. And then you're also going to want to ask them on a daily basis. Either you can do a temperature check, or ask them to do their own temperature check, and ask them if they have a fever of 100 degrees or more. The last question you might want to ask, although it's probably not as relevant at this point as it was earlier during the crisis, is whether the person has traveled to another country in the last 30 days, which they probably haven't because of all the travel restrictions. But you want to make sure you understand if the person has been traveling either outside the state or outside the country recently.
Okay, the next question is, what do we tell an employee who has been working from home who does not want to come back to the office? The employee prefers to work from home and thinks that in their mind they should be able to.
Well, a lot of employers are allowing people to continue to work from home if they can do that productively and continue to do their job, and then asking people to voluntarily come back into the workplace in phased increments. So for right now, the recommendation is to allow people to continue to work from home. If they can work from home, they can do their jobs from home, and they can do so productively. Now, if they can't, and you actually need them to be back in the office for work-related reasons, and it's not possible for them to continue working from home, then you can tell them that they do have to come back into work, and you should explain to them, like you should explain to all of your employees, the precautions and the steps that you're taking to make sure that the workplace is safe and healthy for people to come back into work. So you can allow people to continue to work from home, but if that's not feasible, you can also require them to come back into work, depending on your circumstances and what type of job that person does.
Does your response change at all if the reason that the employee does not want to come back to work is because they are scared of exposure to the virus?
Well, potentially. I mean, there's probably a lot of people who are scared to come back to work because of the virus right now, to varying degrees. And so employers want to be sensitive to that and be flexible with that to the extent that they can and still run their operations. But fear of coming back to work is not, that's not going to rule the day. So if you have somebody who is not in a high-risk group and doesn't have a medical reason or an age-related reason why they need to continue to work from home, then you can insist that they come into work. And if they refuse to come into work, they can potentially be fired. Hopefully that would be the outcome of the situation, but just a general fear from a healthy person, otherwise healthy person who's not in a high-risk category, is not a reason that they should be able to stay out of work if you actually have to have them at work to do their job.
Okay, I've got just 3 more questions, so I'll try and power through them. The first, is there a limit on how often the employer can require its employees to take a retest, for example, every quarter?
No, there's no limit that I have seen on how often you can require an employee to take a test. If you have access to tests and you're able to have your employee take a test and you're going to pay for it, then there is no limit that I've seen on your ability to do that.
Next, can an employer require antibody test and or a nasal swab?
Yes, the employer can require, if you have access to those types of tests, you can require tests that would either demonstrate that the person has had the virus or is negative for the virus. Now, again, as we know, just based on everything we know as of today, even the antibody test isn't, we don't know that it is 100% guarantee that that person could not become reinfected in the future. So, you know, taking into account everything that we know just from a medical perspective and a scientific perspective, while you can require antibody tests, we don't know if that means that that person can't be reinfected.
Okay, next up. If an employee does not normally use daycare, but a family member is not able or is concerned about watching the children, does this employee qualify for FFCRA even though childcare companies are available?
No, the FFCRA leave is only available for childcare reasons if the person, if the children cannot go to a school or daycare because they are closed. So, and the person doesn't have anyone else, the employee doesn't have anybody else who can take care of the children. So they've got to be able to show that their regular provider is not available for coronavirus related reasons. And they've got to provide that documentation so that the employer has that documentation so that they can support the request for a tax credit reimbursement for giving that paid leave. So there's got to be some way to document that the person doesn't have access to other care and or their school, their child's school is closed.
Okay. I have a couple more questions, Melanie. Do you have time?
Of course. Yeah, absolutely.
Perfect. Next up. Because I live with a high-risk person, does that allow me to be considered high risk and to be allowed to work from home?
It potentially could, yes. So that's why you want to, if you are in that situation where you live with somebody who is a high-risk person, the employee should bring that to the employer's attention and talk that through with them. And if the employers or the employee is able to continue to work from home, especially as the country and the states go through this phased reopening period, then that is something that the employer will want to take into consideration when deciding whether or not to allow that person to continue to work from home.
And so somewhat related, if the employee is considered a high-risk employee, can the employer require the employee to work at the office?
So the employer can't, well, if the employee, I'm going to go back to the EEOC guidance slide here. So if the employee doesn't request an accommodation, then the employer is not required to provide an accommodation, even if that employee might qualify for one. So if the employee isn't requesting an accommodation, and even if the employee may qualify for one, the employer doesn't have to accommodate that person. So, Hannah, correct, the question was whether you can force that person to come back into work?
Yes.
If the person cannot work from home and teleworking is not an option, then you can require that person to come back to work. But if they have an underlying disability, you have to go through the reasonable accommodation discussion with that person about whether or not they need a reasonable accommodation to continue to do their job. And if teleworking is a potential reasonable accommodation for that person, then you might need to allow them to continue to work from home.
Next up, can an employer get FFCRA tax credits if they received a PPP loan?
Yes. Well, they can't get if they can't get double reimbursement, to put it that way. So if the PPP loan funding is being used for leave time off for the employer that could potentially include FFCRA leave, then the employer can't use the PPP funds that are conceivably going to be forgiven and then also seek tax credit reimbursement for the FFCRA leave that they may have paid out.
can you remind us what state adopted the workers' comp rule?
Yes, it was California.
Okay. Next up, what if an employee cannot do their work 100% from home? Under EEOC, if the employee can only do 75% of their work from home and someone else has to do the other 25%, can their pay be adjusted to compensate for the additional personnel required to fill the gap?
Well, you can require, a person has to be able to do all of the essential functions of their job without a reasonable accommodation. So, but if 25%, I obviously don't know what the job duties are that you're referring to, but if 25% of the person's job is a marginal job function, then that can be assigned to someone else to do temporarily, then that might be an accommodation that you have to live with for the time being during this crisis if the person can only do 75% of their job from home and they have an underlying condition that is a qualifying disability. Now, as far as adjusting pay, you cannot negatively affect somebody's pay simply because they've requested a reasonable accommodation. So you can't lower their salary just because they are being reasonably accommodated. However, if 25% of their job are not marginal job functions and they are essential functions of that person's job, then you need to be looking at whether you need to put that person in a different type of position where they're being accommodated but also able to do the essential functions of their job. So to answer that question accurately, I would need to know more about that person's job and what their job functions are. But you do need to be looking at reasonable accommodation issues when you have somebody who is only able to do part of their job remotely.
Okay. As a small employer, less than 25 employees, is an employee eligible for relief under the FFCRA if they are caring for an elderly parent who has not been diagnosed with or exposed to COVID-19?
No, the FFCRA leave is only available for employees, the extended leave, the FMLA leave, is only available for employees who are taking care of school-age children who are not in school or daycare because of COVID-19 related reasons. It cannot be used for taking care of an elderly parent who does not have COVID-19 or COVID-19 symptoms. Now, the person can use regular FMLA for that reason, which is unpaid leave. But the FFCRA expanded FMLA leave is not for, you can't use that for taking care of an elderly parent.
Okay, and then for employee taking extended FMLA leave due to school closure, should there be new documentation required for EFMLA after the normal school year would end?
Yes, you can ask for additional documentation for closures of schools and daycare after the regular school year has ended, so that you know and you have documentation to back up your request for tax credits that leave is being used for an appropriate purpose. So Hannah, it's 12:10, and so if there are additional questions, I think we will go, I will answer those questions in writing and we can send an email out to the attendee list, but we want to be mindful of everybody's time. So thank you, Hannah, for helping and asking me all those really great questions. And thank you everybody for attending the webinar. I hope this was useful information for you. And please reach out if you have additional questions that we were not able to answer today. So thank you very much.